Swayam Prabha. Digital India. Educated India.
Dear viewers, I welcome you all on this lecture number 6 on the topic of interpretation of statutes. My name is Dr. Ajay Sonavne, Assistant Professor, Faculty of Law, University of Delhi. Dear viewers, today we will be discussing on the topic of rule of interpretation part 1. There are actually several rules under this interpretation of statutes. So we have divided this topic of rules of interpretation of statutes in two parts. So today we will be discussing part 1. So before we begin with the rules, let us understand that what rules that we are going to discuss in this particular lecture. So we will be discussing three important rules in this lecture, that is one, literal rule of interpretation, second, golden rule of interpretation, and third, the mischief rule of interpretation. So to begin with the first one and to have the background that how these three rules of interpretation is basically plays an important role under this topic of interpretation of statutes. So it is very important to understand the intention of legislature. So whenever the lawmakers prepares the law and that law come into force, and also when the judiciary interpret that law, what is the intention behind that? That needs to be recognized, that it needs to be understood, and accordingly it should be applied to the particular facts of the case. So here we have these three primary important rule that we are going to discuss today. That is number one is the literal rule, second is the golden rule, and third is the mischief rule. So to begin with the first one, literal rule. So as from the title itself, if you can see, it suggests that literal, that means that we have to apply law as it is, or we have to understand the wordings of the statutes as it is. So wherein this is a very basic and fundamental principle of the interpretation of statutes, and it in this particular rule of this literal interpretation, wherein the judges or lawyers or the learners will give the interpretation to the statutes, the meaning that it holds, that is a natural meaning, that is precise meaning, and that is the very simple meaning that can come out from the words of the statutes. Then here if you see that clear and direct meaning along with the core purpose and objective of the respective statutes. So while interpreting that word, we have to remember that the clear and direct words, definitely we are giving the meaning to that, but along with that we have to remember that the purpose and objective of that statute also must be served. And this rule also sometimes called as a plain reading rule, and this rule is also a part and parcel of rules of strict interpretation, because here the judges will have a very less scope to interpret the law beyond the boundaries of the words of the statutes, or beyond the meaning that can be, no, one may apply certain philosophy or one may apply some ideologies, so that will not be applicable when it comes to the literal rule of interpretation. So the rules of strict interpretation will be applicable here. So the words of the statutes will be strictly applicable when it comes to the literal rule of interpretation. So when they are going to apply the meaning, then simple and popular meaning used in common parlance, that should be applied. So one need not go to apply some modern or some contemporary or something which is not relevant to the act, or something which is not mentioned in the act. So one has to just apply very simple straightforward meaning to the particular words of the statutes, and as understood by the common civilians in their daily life. Further, no addition or substitution of words that should be done when it comes to the literal rule of interpretation. What law is, that is important, and not what law ought to be. So we have to follow the what law is rather than what law ought to be, because when we go for the what law ought to be, then there are certain modification will come, certain amendment in a sense that certain interpretation will be in some much wider sense that can be applicable. But when it comes to the law, what law is, then one has to just apply the wordings as it is. As quoted by Viscount Handlin, that if the language used has a natural meaning, we cannot deviate from that meaning unless, when reading of the statute as a whole, the context directs us to do so. And also in continuation with that, Maxwell states that the plain meaning rule, as it is now recognized that the paramount duty of judicial interpreter is put upon the language of the legislature, honesty and faithfully, its plain and rational meaning, and to promote its object. So, we will now understand this principle of literal interpretation or rule of literal interpretation along with certain landmark judgments, because here we have to understand the application of this rule as well. So the landmark cases or the judgments will be useful for us, that to understand that how the judiciary has applied this principle of literal interpretation in certain cases or in the facts and circumstances whenever they have come across such situation. So here there is a first case that briefly we will discuss, that is Motipur Zamindari Company versus State of Bihar, AIR 1962 Supreme Court case. So in this case, the primary question, if you see here, that was raised, that whether the sugarcane falls within the term green vegetable under the Bihar Sales Tax Act. So here the words like sugarcane or green vegetables that are generally used in our daily life, daily routine. But the question here arises that whether this category of or the element of the sugarcane can be equated with the green vegetable or whether it is a part of the green vegetables. So here Supreme Court observed that in the common day-to-day life, the use of sugarcane is not used as a vegetable in the households. So therefore, it cannot be exempted, because this Bihar Sales Act basically exempts the green vegetable from the paying of the taxes. But the sugarcane cannot be equated with the vegetables, because the nature of both the articles, or you can say both the subject, is very different. So therefore, the sugarcane cannot be equated with the vegetables, because green vegetables may be used in our daily life, in our daily kitchen routine, but the sugarcane may not be having the same kind of usefulness in our daily routine, kitchen routine. So therefore, the purpose of Bihar Sales Act to exempt the vegetables is something specific, and that cannot be equated for the sugarcane. Moving ahead, we have another case, Jugal Kishore versus Raw Cotton Company 1955 Supreme Court case. Now in this case, if you see here, the facts of this case are such that there are two Habib brothers who are carrying the business of merchants under the name of Habib and Sons. Okay, and they had filed a summary suit against the present appellant, that is Sugar Kishore, for the recovery of money. Now in between, the Habib and Sons transferred their business to Raw Cotton Company, and during this transfer, the Raw Cotton Company did not substitute themselves as a plaintiff in place of Habib and Sons on the record, and allowed it to be continued in the name of original plaintiff, that is Habib and Sons. They could have done it under the Orders 22 Rule 10 of CPC. Now here what happened, that the Habib and Sons, when they transferred the business to the Raw Cotton Company, their previous matter which was pending, and that is nothing but the against the appellant of this case, that is Jugal Kishore. So they did not, however they transferred the business, but they did not transfer the or substituted themselves like as a Raw Cotton Company, because once the business has been transferred, so everything has been transferred to Raw Cotton Company. But when it comes to the matter which was pending, or the amount for the recovery of money from this Jugal Kishore, so they did not change the name of the plaintiff. So there should have been a name of Raw Cotton Company, because business is now handed over to them. So here, but when the court passed the decree, then in the favor of plaintiff, that is in the favor of Habib and Sons, then later the Raw and Cotton Company applied for the execution of decree under Order 21 Rule 11 of CPC. When the matter came in the favor of, or the decision that was given by the judge in the favor of Habib and Sons, then the Raw Cotton Company realized that there is some plus points or benefits, so then let's apply for the execution of decree. But now here issue arises that can they do so, because however they are the owner of the company now, but can they do so? So therefore, the primary issue in this case was that whether Raw Cotton Company can claim to be transferred of decree within the meaning of Order 11 Rule 16 of CPC. So Raw Cotton Company here prima facie cannot file the execution of decree, but here Raw Cotton Company argued, stating that the decree was not in existence at the time of transfer of the property. So the thing which was not exist, how it can be transferred? So that was their argument, because when the Habib and Sons transferred the business to the Raw Cotton Company, at that time there was nothing to transfer like a decree. So decree came after some time. So now when it was not transferred at that time, so now they are appearing before the court to get the execution of decree and also to transfer the decree into their favor. So the cardinal rule of construction of statute is to be read literally here, and that is by giving to the words used by legislature in their ordinary, natural and grammatical meaning. So if however such reading leads to absurdity and the words are susceptible to another meaning, the court may adopt the same. Otherwise, court must adopt the ordinary rule of literal interpretation. Now here in the present case, if you see here that a literal interpretation of the rule leads to no apparent absurdity and therefore there can be no compelling reason for departing from that golden rule of construction. So because at the date of document they had a right to proceed with the suit and get such relief as court by its decree might award, but no decree had been passed at that time and therefore the property to which they were entitled could not include any decree might be in future that has been passed. So even they had transferred the business from Habib and Sons to the Raw Cotton Company, in the document itself they could have added that in future if there is any decree pending, if the decision comes in the favor of like Habib and Sons or the plaintiff or maybe in that case Raw and Cotton Company, then that benefit will be given to them or that opportunity will be given to them to approach to the court for the execution of the same, but it was not mentioned. So therefore by reading the simple document, no provision perpetuating in terms of the transfer of any future decree. So if the document has not mentioned anything, so therefore there is no question that they can get a right to approach to the court for the execution of the same. So therefore the true position is that date of transfer of the debt to the respondent company and the transferors could not transfer the decree because the decree did not exist. So okay, so there is another judgment that we can see here, that is Ram Avatar Budya Prasad versus Assistant Sales Tax Officer 1961 Supreme Court case. So here in this case there were 3 petitions under Article 32 that were filed before the Constitution before the Supreme Court, and in this case it was primarily for the imposition of the sales tax on betel leaves by the sales tax officer under the provisions of the CP and Bearer Sales Tax Act 1947. So these 3 petitioners basically are the dealers in betel leaves, and in all the submissions of the petitioners was that the order demanding the tax was without the authority of law, in as much as betel leaves were not taxable under section 6 read with the schedule 2 of the act, because here the contention of the petitioners was that these betel leaves are not basically taxable under the section 6 that can be read with the schedule 2 of the act, but however the sales tax officer had imposed the tax on them. Now let us see what is the reason behind that. So it was alleged that the imposition of tax is an infringement of the petitioner's right to carry on trade business guaranteed under Article 1G of the Constitution, and the prayer was made before the court that the issue of writ of certiorari quashing the order of assistant sales tax officer and for the prohibition. So the schedule was amended by the CP and Bearer Sales Tax Amendment Act, by which item 36 the betel leaves were omitted. So here this amendment is again plays an important role, because according to this amendment these betel leaves were omitted, and because of this omission that becomes now eligible to pay the sales tax. So here it was also submitted that betel leaves are vegetables and therefore they would exempt from the sales tax under item number 6. But the reliance or the emphasis was placed on the dictionary meaning of simple word like vegetable as given in the Oxford Dictionary, wherein the word is defined as of or pertaining to, comprised or consisting of or derived, obtained from plants or their parts. So here when we correlating these 2 words, vegetables and you can say betel leaves, so whether the betel leaves are vegetable or not, that is the primary question, because as per the amendment the item number 36 wherein already it has been omitted, but further it says that subsequently betel leaves were removed from the schedule, which is indicative of legislature's intention of not exempting betel leaves from the imposition of tax, and therefore what is the reason behind that, why they have removed the betel leaves from the list? Because betel leaves must be construed not in any technical sense nor from any botanical view, but as understood in a common parlance, because that is what the literal rule of interpretation. The term vegetable is to be understood as a commonly understood, denoting that a classes of vegetable matter which are grown in kitchen garden and are used for the table. So betel leaves are not exempt from the taxation. So therefore these petitions that were filed, that failed and that were dismissed, because ultimately when we talk about the betel leaves and when we compare the features of betel leaves with the vegetables, both are having the different features, and again they are even with the legal recognition that has already been removed from the list. So therefore betel leaves cannot be exempted from the tax. So therefore these petitions were rejected. So here what we can understood is that the literal rule of interpretation is such that what law has prescribed, what law has emphasized, what law has written, that should be understood with the plain clear manner. There should not be anything that should be applied which is not in the law. Again there is one more example which is again associated with the green ginger and the vegetables. So here you can see there is a case, State of West Bengal versus Washi Ahmad, 1977. So whether a green ginger falls within the category of goods described as a vegetables, so commonly known as sabji, tarkari or sack. So item 6 of Schedule 1 of Bengal Finance Act 1941. So here again the question arises that what about the green ginger? So here the sales tax authority imposed a tax on a green ginger and held that green ginger is used to add a flavor, taste to the food and therefore cannot be called as a vegetable, commonly known as sabji, tarkari or sack, because the green ginger may not be having its independent identity or may not having a independent, like even if you cook in the kitchen, then green ginger may not have that dish maybe of especially of the green ginger. So therefore it cannot be equated with the vegetable. That was the contention of sales tax authorities. But further the orders of the sales tax authorities were challenged with the help of writ petition under Article 226 before the single judge of High Court, who heard this writ petition and disagreed with the view taken by the sales tax authority and held that green ginger is a vegetable within the meaning of expression that is mentioned under item 6 of the first schedule to the act. And this view learned under single judge was affirmed by the division bench, and hence in the present appeal now has been filed before the Supreme Court by the sales tax officer. So now when the matter came before the Supreme Court by the special leave petition, then here by referring to the previous judgment by the Supreme Court, such as the Ram Avatar Budaya Prasad or the Motipur Zamindari case, so wherein in both the cases court has found that the word which may used in our word of everyday use must be construed not in any technical sense, but they shall be used in a common parlance. No need to go for any botanical point of view or any technical point of view, because if we can read the law in a clear manner, or if we can read the provisions of the statutes in a very literal manner, then there is no need to go and interpret the law in something which is technical or in something which is very difficult manner. Even this construction that has been followed even in the other countries like English, Canada, America, which was referred in this particular judgment. So also there is observation that is put up by the Pollock B pointed out in the case of Grenfell versus RC, and that is, if the statute contains language which is capable of being construed in a popular sense, such a statute is not to be construed according to the strict or technical meaning of language contained in it, but is to be construed in a popular sense. Meaning, of course, by the words popular sense is that sense which people conversant with subject matter with which the statute is dealing would attribute to it. So therefore court held that green ginger is included within the meaning of vegetables, which is commonly known as sabji, tarkari, sack, which is inclusive of item 6 of the schedule, and sales tax authority must exempt from the to impose the tax upon the green ginger. So therefore again this appeal that was filed by the sales tax officer, that was failed. Again there is one more example which is now inclusive of another category of food item, that is butter. So here in the case of M.V. Joshi versus M.U. Shimpi 1961 Supreme Court case, wherein the appellant is the proprietor of the shop and dealer of this manufacturing the butter. So one day, that is food inspector of municipality visited the shop and appellant and purchased from him some quantity of Khandeshi butter and notified that he was going to analyze the nature of butter. So as a food inspector, he's having the authority. So he purchased some butter and also he did some inspection about that quality of butter, whether that butter is inclusive of some other containment or some other you can say items which is not healthy or which is not correct as per the products or as per the rules of the food items. So therefore he divided this butter into 3 equal parts and put them in 3 separate bottles, duly sealed the bottles in the presence of 2 panchas, and he gave 1 bottles to the appellant, sent 1 to the public analyst and kept 1 with himself. Now when the report that came to him about that what is the quality of butter, whether it is anything harmful is there or not, then it was found that the butter contained 18.32% foreign fat, 19.57% moisture and 64.67 is the milk fat. So therefore, considering this report, the food inspector filed a complaint in the Court of Judicial Magistrate First Class against the appellant under this section 16 read with section 7(1) of the Prevention of Food Adulteration Act 1954. And here, because of the butter which was found adulterated as per the section 2(1) of the Act, and therefore appellant had committed offence under section 61 of the Act by selling the adulterated article of food in contravention with the section 7(1) of the Act and the rules made thereunder. Okay, so here now when the matter now came before the Judicial Magistrate First Class, then he basically acquitted the appellant, stating that it had not proved beyond the reasonable doubt, because according to Judicial Magistrate First Class, there is nothing wrong in the quality of butter. So therefore, food inspector filed an appeal against the order of acquittal to the High Court. Then in the High Court, he was convicted under the Act by the High Court and sentenced him a rigorous imprisonment for 2 months and to pay the fine of rupees 250. Then this shopkeeper approached to the Supreme Court by way of special leave against the judgment of High Court. And here now, when the question come before the Supreme Court to understand that whether this quality of butter is, whether it is really adulterated or not, or what is exactly the process for the preparation of butter as which is mentioned in the Act, or even in general common parlance, how do you see the manufacturing of butter, or whether this percentage which has been shown by the report, whether that actually making the butter unhealthy or you can say adulterated as per the Food Adulteration Act. The Supreme Court observed that whatever the process is adopted, whether butter is taken directly out of milk or taken out of sourced milk or cream, it is prepared only from the milk. And shortly it is stated that butter by its product is prepared from the milk. So milk is basically the basic fundamental product, or you can say basic source through which the butter will be prepared. So therefore, the following words in the definition stand out prominently by stating that the product prepared exclusively from butter or cream of cow, buffalo or both. So hence, to be a butter, it should comply with following condition. So because whether it is adulterated or not, Supreme Court went to the very basic common parlance that how the every common individual in their daily routine, how they comply with these conditions. So first is that it shall be a product from the milk. It is said the said milk or cream shall be of that of cow or buffalo. The product shall be prepared from the said milk and it shall prepared exclusively from the said milk. So also here the Maxwell on the interpretation of statute has mentioned that it is now recognized that the paramount duty of the judicial interpreter is to put upon the language of legislature honestly and faithfully its plain rational meaning and promote its object. So with this, when the act was passed to make provisions for the prevention of adulteration of food, the court held that the butter prepared from curd comes with the definition of butter, because according to the food inspector, the butter is prepared from the curd and therefore it is not good for the health. But according to the court, or even the whatever the submission that they had, the butter is ultimately is the outcome of the milk and it is not only from the curd. So therefore court imposed a sentence of fine that would meet the end of justice in the present case, and Supreme Court set aside the sentence that is given by the High Court, which was rigorous imprisonment and the fine of rupees 250. Instead of that, the appellant has to pay the fine of 500. With certain modification, this appeal was dismissed. So this literal interpretation basically achieves this particular goal. So let us now try to understand what are the advantage and disadvantage of literal rule of interpretation. So after analyzing some of the judgments, so these are the some of the advantages that you can understand, or you can also realize that this literal rule of interpretation, first, it ensures the certainty and clarity, wherein the judge has interpreted the law as it is, wherein there is no anything that has been added or substituted. The word has been interpreted with their plain meaning and with their plain understanding. Second, it promotes the separation of powers. Why? Because when a judiciary interpreting the law with their literal interpretation, then it is also respecting the legislature, that the way they have prepared the law, the legislature, the way they have expressed the law in their statutes. So judge is only going to interpret the law. They are not going to make any other meaning out of that provisions. Third, it promotes legislative precision. Fourth, it promotes, there is no scope for the prejudices or personal belief. So here there is no scope for prejudices or personal belief. So there is a quick interpretation with simple construction. So wherein there is no need to go for any technical or any difficult interpretation, one can simply apply the quick interpretation with the simple construction. But at the same time, there are certain disadvantages as well. So what are the disadvantages? That there is a ignorance towards the intention of legislature. So when a judge going to apply the law with their literal interpretation, then they may not go back to the history, or they may not go back to find out what is the intention of legislature to write this provision in this particular manner. So therefore, intention of legislature is not part of this literal interpretation, that is missing. Second, it leads to sometimes absurdity as well. Then it is very rigid and not flexible provision, because when you see the interpretation of literal rule of interpretation, there is no scope for any flexibility, or one cannot apply or interpret that law with certain modification. It is very rigid, and wherein if it is a strict, then one has to also, if it is a matter of like criminal statutes, then the punishment will be there. There is no excuse for that. Then second, sometimes it may lead to the injustice, because if the literal rule of interpretation is applicable, then also that may not inclusive of the principle of natural justice, and therefore that may lead to the injustice to someone who is not maybe not able to put his stand before the court, or not able to put his argument before the court, so or may not get the opportunity to put the correct perspective. So therefore it may lead to injustice sometimes. And the fourth one, last one, that is the restrict the judges to interpret with changing time and society, because if the legislature, when they have prepared the law in the particular era, like maybe 10 or 20 years back, and if it is going to be applicable like in today's context, then in that case the purpose or the object of that act might have changed, or the society might have changed. And then when the society has changed, then whether the same construction or same interpretation will be helpful or not, that is again question. So therefore it basically restrict the judges to interpret the law with changing time and changing need. Okay, so now let us try to understand the second rule of interpretation, which is again primary rule of interpretation, very important one, and that is the golden rule of interpretation. Now golden rule of interpretation is basically very important rule of interpretation amongst the all three, that is literal, golden and mischief. It is nothing but the modification and advancement in the literal rule of interpretation. It helps to bring out the real intention of legislature. So wherein in the literal rule we literally apply the rules of interpretation, or we literally interpret the words. But here the situation is sometimes that the lawyers, judges, they may try to gain the real intention of legislature. It also avoid the absurd or vague meaning. Judge will take a different view or deviate from the literal rule of interpretation. Then application of golden rule leads to reasonableness and also fair decisions. And when the words or phrases of the statute do not fit with the natural meaning and create absurdity, uncertainty, or are superficial, the golden rule of interpretation adhered to. Here there is good observation that is given by in the case of Gray versus Pearson, wherein it was observed that the grammatical and ordinary sense of words is to be adhered to unless that would lead to some absurdity or some repugnance or some inconsistency with the rest of the instrument, in which the case the grammatical and ordinary sense of words may be modified so as to avoid the absurdity and inconsistency, but no further. So basically, to avoid the absurdity, to avoid the vagueness, to avoid the you can say confusion, the golden rule of interpretation basically helps that wherein the literal rule may not be applicable as or may not give the result, but golden rule with the help of certain deviation, certain modification, it can bring some better result for the good application of law to the respective situation. So we have certain cases here again under this golden rule of interpretation, which can give us the some application of law or application of this golden rule of interpretation in the particular situation. So there is this first case, that is Lee versus Knapp. So in this case, defendant was going to the office in his car and he parked his car on the road and went to his office. Unfortunately, the car ran into the another's vehicle. Now here, as he left the car and going away to his company's office, the defendant committed a breach of section 77 of the Road Traffic Act 1960, which provides that if in any case owing to the presence of motor vehicle on road, an accident occurs whereby damage is caused to a vehicle other than that vehicle, a driver of motor vehicle shall stop, and if required so to do by any person, give his name and address. Okay, so this word here, two important words that we have to remember, that is stop and give name and address. So here, when the defendant has reached to the office and when his car run into the another's vehicle and left without taking any precaution or without taking any action, he just left the car as it is and went to his office, right? So therefore it was mentioned that he has a breach this section 17 of the Road Traffic Act, because here the word has been used that if such accident occurs, then driver of motor vehicle shall stop and if required so do so by any person, give his name and address, because this expectation is there from the law. So in the present case, the court observed that literal interpretation of the word stop would lead to absurdity into the meaning and the purpose of the section, which can easily be avoided by applying the golden rule of interpretation. So therefore, defendant convicted by the magistrate, because here if you see the word stop, right? So here if we just apply the word stop, that means that if some accident happens and if there are A and B is there and A has met with accident to B and A is the responsible for the same. So as per the section, A immediately stop the car, come out of the car, see that there is an accident that has happened because of him, and he again sit in the car and again he go. So here, what is the purpose of stop? The word stop which is mentioned here, the purpose of that word stop is that that person should stop, and if required he should also give his name and address just to give the assistance to the person who is injured one or who has suffered certain injury. So it is not just for the sake of the section or for the sake of law that one person has to come out of the car and just to stop. It is not that. One has to come out of the car, one has to stop, one has to do whatever the possible help or assistance can be done, and this is possible with the help of golden rule of interpretation. If we just apply the literal rule of interpretation, then one can say that I had stopped the car, I came out of the car and I left. So that is not the right interpretation. So therefore, in this case, defendant was convicted by the magistrate because of the wrong which he has committed. Moving ahead, we have another case, that is G. Narayan Swamy versus G. Paneerselvam 1972 Supreme Court case. So in this case, now there was election that was happened on 11th April 1970 in the Madras Legislative Council from the Madras District Graduate Constituency, and which was set aside by the learned judge of the Madras High Court. What was the reason to set aside this election is that the only issue decided in this case against the appellant, which was now before the Supreme Court, was whether the first respondent was not qualified to stand for the election to the graduates constituency. So here this, as you can see, this election was specifically for the Madras district graduate constituency. The word graduate, that shows that it basically the members or the people or who are associated with this are somewhere having some educational background. So the appellant, that is Narayan Swamy, who had only passed the high school leaving examination and was not graduate, and he has basically won the election. Therefore, it was claimed that it would be absurd or destructive that the very concept of representation of especially qualified person, that an individual who does not possesses the essential or basic qualification of the electors should be a representative of those who are to be representative because of this special qualification of theirs. So if it is an election that is associated with the certain graduates, and the person who has won the election, he himself is not graduate and just passed the high school leaving examination, whether that is correct or not. This is what one argument. But if you see this from legal perspective, then there is Article 171(3) of the Constitution, and the Constitution being the organic instrument for the governance of the land, and it must be interpreted in a particular broad and liberal manner so as to give the effect to the underlying principle and the purposes of the system of representation sought to be set up by it, and not in such a way as to defeat them. So hence the question here arises that whether this educational qualification really matters or really important when it comes to the graduation, this election, or whether the law has clearly prescribed whether the educational qualification is the only criteria to contest the election. So therefore, the education qualification of the electors should be read into the system of representation set up by the Constitution for legislative councils as necessary qualification of the candidates in such constituency. And the plain and ordinary meaning of term electorate is confined to the body of persons who elect. Thus, in laying down the test of competence of voters of such constituency, mere possession of degrees by them was not considered sufficient, because when you are contesting the election, it is not always, especially in this case, that your possession of degree will be sufficient qualification. So after considering all the relevant constitutional and statutory provisions, court found that appellant possesses all the qualification that is laid down for such candidate, because the law also does not prescribe that what shall be the exact educational qualification, and plus apart from the educational qualification, what other things are required, even that needs to be taken into consideration. So merely if the candidate is just high school qualified or high school examination pass, that doesn't make the criteria to disqualify him from this election. Therefore, court accepted this appeal and set aside the decision that is given by the High Court to set aside the election. Okay. Then there is one more case, that is Knox versus Doncaster Amalgamated Collieries 1940. So wherein the court made an order under section 154 of Companies Act transferring all the properties and liability of the transferor company to transferee company, and in the result that a contract of previously existing existing workers, an individual and the transferor company automatically becomes a contract between the individual and transferee company. So here the if I just simplified this, it says that one company, that is A company, has transferred their business to B company, right? And when A company has transferred their business to B company, then what about the employees who are working in that previous, that is A company? Whether all will be automatically get transferred to B, or their position will be get transferred to B, or will there be a other contract which will be prepared by B, and then they can be continue to work there, or and then they will continue to work there in the B's company, or whether it is automatically transfer of like A, in A company whoever are the workers, they will automatically get transferred to B, and B will take them in their company and they can start working again. So in this case, the counsel for the appellant argued that a contractual right of personal service was a personal right of the employer and was incapable of being transferred by him to anyone else, and that duty to serve specific master could not be part of property or rights of that master capable of becoming by transfer a duty to serve someone else. So there must be a great advantages in avoiding the necessity of liquidation and the effecting the transfers without any further act or deed in case of contemplated by this section. So in the second place, if the legislature really desires, the workman should be transferred to a new employer without their consent being obtained. Plainer words can be devised to express this intention. So these appeals should be allowed on with the cost here with the below, and The question of law raised in the case stated should be answered by saying that a contract of service did not exist between the appellant and the respondent. It was just a mere the transfer of business between A to B, but the contract of service of the workers to the new company, that was not made, and that's supposed to be made, and accordingly they can get the benefit of the same. So here now, what are the advantages and disadvantages of golden rule of interpretation? So if we analyze the cases and if we analyze the application, then we can come to the conclusion that the advantages are such that this golden rule of interpretation reaches to the clarity with the best possible interpretation, wherein we are not applying the rule or the statute with the strict interpretation. We are applying or trying to reach to the best possible solution or the interpretation of the statute. Second, we avoid the loopholes under the literal rule of interpretation, because under the literal rule of interpretation, that may sometimes lead to injustice, that may sometimes lead to the unable to give, that sometimes may not give the flexibility to the judge. So here, whatever the loopholes that we have in the literal rule of interpretation, we are trying to cover up under the golden rule of interpretation. Then third, we have respect the law and intent of legislature. Then next, we have reduce strictness of literal rule of interpretation. Then provide reasonable decisions, because this reasonable decisions is nothing but that we are trying to come out with some best possible interpretation, and that will obviously lead to the reasonable decisions at the end. And also remove the errors in law. So sometimes if the law is not very clear in the interpretation, so we try to give the better meaning so that we can take out the better meaning from it and we can interpret that in the same manner. Then what are the disadvantages? Disadvantages is nothing but that there is no specific guideline of interpretation, because the way the requirement is there as per the society, time, or you can say as per the situation or circumstances, the judge will apply or interpret the law with some flexibility and try to give the meaning to the words of the statute. So sometimes that application may not be applicable in general sense, that may be applicable to one particular case. So therefore there is no uniformity as such when it comes to the interpretation, or there is no specific guideline that what scheme that one should follow. Then it is very rarely used by the judges, because as you know that judges has limitation definitely, that they can interpret the law which is mentioned in the statutes, or which is words which are mentioned in the act or statutes, but they cannot frequently apply the rule of golden interpretation or give the different meaning or some other better meaning for every time. So it is first that they have to see that what is the nature of law, whether law is in the category of penal statute, or you can say in the tax statutes. Then in such cases golden rule will not have a place to apply. But in some other statutes, maybe it is a social welfare legislation or beneficial legislation, then in that case the golden rule may be applicable in such situation. And third one we have is the no use if words are clear and not absurd. So if the words of the text are very clear, if the words of the text are very not ambiguous, or you can say not vague, so in that case there is no place for the golden rule of interpretation, because golden rule of interpretation comes into picture or can be used when the words are not clear or words are not giving the correct meaning. Now we will now come to the third and the last rule of interpretation in this part 1, that is mischief rule. So mischief rule, as you can see, it is also can be termed as evil, right? So to interpret the statutes in the light of mischief or evil. So what do you mean by this mischief rule? This is again very important rule that we have to remember. This mischief rule basically resolve ambiguities in cases in which the literal rule cannot be applied, but at the same time use of this rule is limited to the parliamentary intent. And mischief rule is often referred as the hidden rule. This is very important case, and through this case basically this mischief rule basically evolved. This rule basically gave certain guidelines that when we apply the mischief rule, then what things that we should keep in mind. So hidden rule is very important case reported by the Lord Coke, decided by the barons of Exchequer in the 16th century, because this hidden rule is basically, as I mentioned, it is the foundation of this mischief rule. So let us understand that what are the principles that are laid down by under the hidden rule. So 4 things that we need to understand when we apply the mischief rule. These 4 questions that one should ask or one should apply when they are going to apply the mischief rule. So first question is that what was the common law before passing of the act? Because if you just see the certain legal provision, or you can say certain development in the law, then most of the times the law basically developed initially, like in the subject of torts, for example, then law is basically based upon the common law system. So the principles that is evolved through the judiciary that were followed through the number of years, or you can say through the number of generation. So first we have to understand that what was the common law before passing of the act. So when the law is declared by the court, that is nothing but the common law. Then when it turned into the act, when the parliament makes that or turns that common law into the act, then what was the no prior situation of the court rather than checking the act. So what was the common law before the passing of the act? Second, what was the mischief and defect for which the common law did not provide? So however judgment might have been passed, but what mischief or what remedy or what defect that was still there, that they could not give the remedy for the same. So that we have to answer. Third, what is the remedy now provided by the act of the parliament to deal with the mischief or defect for which the common law did not provide or cure? And fourth one, the true reasons for the remedy. So here these four stages are very important, that what was the position in common law before passing of the act. Second, what was the mischief and defect which common law did not provide. Third, the remedy now which has been provided by the act of parliament to remove that mischief or defect. And what is the true reasons for the remedy? What is the justification given by the parliament or legislature to come out with this particular remedy? So here this hidden rules, why it is important to understand, because that we must find that what was the mischief and defect for which earlier law did not provide, and what remedy that parliament has resolved and appointed to cure the mischief. These two steps that we have to remember very carefully when we talk about mischief rule. And having answered this question, then judge had a duty to construe the act in what manner. So first, suppress the mischief. What was the defeat, what was the defect which was there, that has to be suppressed. Then advance the remedy, then give the, you can say, space to the remedy, give that remedy a front seat and apply that remedy to the particular situation. Then third, we have suppress anything that would lead to the continuous of the mischief. And the last one, we have advance the cure and the remedy according to the true intent of the makers of the act for the public benefit. Because in the common law system, that is prior to passing of the act, when the law which was followed, that was declared by the judiciary, but the act when it is passed, that addition to the common law system and the defect, giving the remedy to that defect, then act will be definitely a good source of you can say the information or the application for the upcoming situation. So therefore it is now duty of the judges to adhere to these four schemes so that they can apply the law in a better manner. So now here we have certain example or certain cases that can, with the help of that, we can understand that what is mischief rule. Okay, so there is first case we have here is the Smith versus Hughes case, that is 1960. Now here the defendant was a common prostitute and solicited a man passing in the street for the purpose of prostitution from the first floor of the balcony. Okay, now here it was contended on behalf of the defendant that the balcony was not a street, okay, under the meaning of section 11 of the Street Offenders Act, and that is according to the no offense when it was committed. So here question now arises that whether in those circumstances appellant was soliciting in street or public area. So here basically this act, that is the section 11 of the Street Offences Act, this act was primarily enacted just to make sure that while someone is passing from the road, especially in the area of especially from this area, then the prostitute or common prostitute should not solicit a man, or that man can freely walk on the road. So there but now here the situation is that the common prostitute basically solicited the man from the balcony and not from the road. So here the section 1 of the act in its form, it says that it shall be an offense for a common prostitute to solicit in a street or public place for the purpose of prostitution. So she, being a common prostitute, did solicit in street for the purpose of prostitution, which is contrary to the section 1 of the street offences. But the words of section 11 of the act of 1959 in this are in this form, that it shall be an offense of common prostitute to solicit in a street or a public place for the purpose of prostitution. So it was found that defendant was a common prostitute and that she had solicited, and that the solicitation was an act was intended to clean up the streets and to enable a people to walk along the streets without being molested or solicited by a common prostitutes. So it can matter little, that is, whether a prostitute is soliciting while in the street, or is standing in a doorway or in a balcony or in a window, or whether the window is shut or open or half open. In each case, her solicitation is projected to and addressed to somebody walking in the street. Therefore, the prostitutes were held guilty of solicitation in the street and the appeals were dismissed. There is another case we have here, that is CIT versus Sodra Devi 1957, wherein there was a partition between the joint Hindu family of Sodra Devi along with her 6 children, and later on they made a partnership between Sodra Devi and her 3 major sons, and other minor sons were beneficiary in the partnership. By referring to the section 16(3) of the Indian Income Tax Act 1922, in computing the total income of any individual for the purpose of assessment, there shall be included so much of the income of the wife or a minor child of such individual as arises indirectly or directly. The High Court, upon the reference, came to the conclusion that it was not the intention of legislature to include in the income of mother and income of her minor child. So therefore, the issue before the Supreme Court, whether the word individual in the section 16(3) of the Income Tax Act 1922 includes also female, and the income of minors is liable to be included in the income of mother. So here again the mischief rule plays an important role, because the Income Tax Inquiry Report 1936, which shows that what was the mischief and which has been cured or remedied by the Parliament. So on the basis of Income Tax Inquiry Report 1936, the court observed that mischief rule was sought to be remedied by the inquiry committee. Recommendations was the one resulting from the widespread practice of husbands entering into nominal partnerships with their wives and fathers and admitting their minor children to the benefits of the partnership which they were members. The evil of tax evasion was sought to be remedied by the enactment of section 16(3) in this particular act. So therefore, there is a majority and minority view in this particular case, wherein the Justice N.H. Bhagwati here held that the only intention of the legislature by putting the words in individual or such individual as used in section 16(3) could only have been meant as restricted to the male and not including the female of the species. But there is a minority view by Justice S.K. Dasan, which is the important one to understand here, that he disagreed with the majority view and stated that the word individual includes both male and female. After analyzing the principle of statute, must read as a whole, and this word individual was present in the other provisions as well, which is inclusive of male and female. So therefore, when there is an imposition of tax, that difference should not be made from the word, that is word individual. If it is inclusive of male and female, then that importance or that interpretation should be given. There is one more case wherein the RMCD versus Union of India 1957, the definition of price competition under section 2D of Price Competition Act 1955 was held to be inclusive of only those instances in which no substantive skill is involved. So thus, those price competitions in which some skill was required were exempt from definition of price competition under the section 2D of the Act. So hence, the Supreme Court has applied the hidden rule in this case to suppress the mischief which was intended to be remedied, as against the literal rule which could have covered the price competitions where no substantial degree of skill is required for the success. So at the end, now let us understand the advantages and disadvantages of mischief rule. So here, the more beneficial mode of interpretation as compared to the golden and literal rules, it avoids the when we apply the mischief rule, then it avoids the unjust or absurd results in the sentencing. It removes the loopholes of the other rules of interpretation, plus it ensures the development of law with the changing time and need, because here when the law is going to be applicable, then that will be applicable with the help of new remedy that has been sought by the particular act. But at the same time, there are disadvantages too, that it is very old principle, or you can say it has been followed on the certain old remedies or old principle, then generally applied in the old common law system when the law was newly came into existence. So when this principle was in existence, that time this mischief rule came into existence, then it is generally useful when the legal system was based on the common law system. But now legal system is mostly first law that is enacted by the parliament, then that is came into force, then if someone violates that law, then judiciary takes the decision. So therefore this is old common law principle. Then act may be declared as a crime after an event, and then liberty to a judge with his own views or sense of morality and prejudices to the case is again disadvantage of this mischief rule. So in the conclusion, I would like to state that there, as we have discussed, that different types of rules of interpretation. Literal rule of interpretation, that its meaning, advantage, disadvantage. Golden rule, again its meaning, advantage and disadvantage. And mischief rule with the, and along with the cases that were relevant to that. So as you can at the end, you can say that every rule assumes the significance as per the need and requirement from case to case basis, and every rule has its own importance, and if we compare the rules with each other, there's some or other advantages and disadvantages that definitely can be taken out from it. So I thank you all of you for listening to this lecture. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I'm not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I'm also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.